Virginia gives landlords broad freedom to set and raise rent, but the state has specific notice requirements and a growing number of local regulations that landlords need to be aware of. The governing law is the Virginia Residential Landlord and Tenant Act, Virginia Code Title 55.1, Chapter 12. And while it doesn't cap rent amounts, it does establish the procedural framework landlords must follow. Virginia does not have statewide rent control or rent stabilization. There is no state statute that limits how much a landlord can increase rent, how often increases can occur, or that requires landlords to submit rent increases to any government agency for approval. Virginia's political and regulatory environment has historically favored property rights and market-based pricing, and rent control legislation has not gained significant traction in the state legislature. However, and this is increasingly important, Virginia has granted localities certain authority to enact their own housing-related ordinances, and some Northern Virginia jurisdictions in particular have been exploring additional tenant protections. Landlords in the Arlington, Alexandria, Fairfax, and Prince William County areas should stay informed about local developments, as the D.C. suburbs have been the most active part of the state when it comes to tenant protection discussions. While no Virginia locality has enacted traditional rent control to date, the political conversation is evolving, particularly in the high-cost Northern Virginia market. For month-to-month tenancies, the landlord must provide at least 30 days written notice before a rent increase takes effect. Under the Virginia Residential Landlord and Tenant Act, changes to the terms of a month-to-month tenancy, including rent, require at least 30 days notice before the next rent due date. So if rent is due on the 1st, and you want the increase to take effect on May 1st, you need to deliver written notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. Virginia doesn't prescribe a specific statutory form for rent increase notices, but a clear, professional written notice delivered by a verifiable method, personal delivery, posting and mailing, or certified mail, is strongly recommended. For fixed-term leases, the rent is locked in for the duration of the lease term. The landlord cannot raise the rent during a fixed-term lease unless the lease itself includes a provision allowing mid-term increases. Common provisions include escalation clauses tied to property tax changes, insurance increases, or CPI adjustments. Without such a provision, the landlord must wait until the lease expires and negotiate the new rent as part of a renewal or new lease agreement. When a fixed-term lease is approaching renewal, the landlord should communicate the proposed new rent well in advance. Virginia doesn't require a specific statutory notice period for rent increases at the time of renewal, because the increase is part of a new contractual agreement, but providing ample notice is good business practice. If the tenant doesn't agree to the new rate, the lease expires at the end of its term, and the tenant either vacates or the parties negotiate further. For week-to-week tenancies, the notice period for rent changes is at least 7 days, consistent with the one rental period notice principle. Now let's cover the restrictions that apply even without rent control. Rent increases cannot be retaliatory. Virginia has a specific anti-retaliation statute under Section 55.1-1258 that prohibits landlords from raising rent as retaliation for a tenant exercising any legal right. Protected activities include making a good faith complaint about habitability to the landlord or a government agency, filing a fair housing complaint, participating in a tenants organization, or exercising any other right under the Residential Landlord and Tenant Act. Virginia's anti-retaliation provision creates a rebuttable presumption of retaliation if a landlord takes adverse action, including a rent increase, within 6 months of the tenant's protected activity. 6 months is a significant protection window, and it means that any rent increase served within that time frame after a tenant's complaint will carry a presumption that it was retaliatory. The landlord must then demonstrate, by a preponderance of the evidence, that the increase was motivated by legitimate business reasons, not by the tenant's protected activity. To protect yourself against retaliation claims, Document the business justification for every rent increase before you deliver the notice. Keep records of market comparables, operating cost changes, and any other factors that support the increase. If you happen to be raising rent within 6 months of a tenant complaint, your documentation becomes especially critical. You need to be able to demonstrate clearly that the increase was planned independently of the complaint. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the Virginia Fair Housing Law, found in Virginia Code Chapter 5.1 of Title 36, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, elderliness, familial status, disability, or source of funds. Virginia's inclusion of source of funds is particularly notable. It means that a landlord cannot raise rent specifically to push out a tenant who pays with housing choice vouchers or other government assistance. The Virginia Fair Housing Office investigates complaints and can take enforcement action, including ordering damages and civil penalties. A pattern of discriminatory rent increases, raising rent for tenants in one protected category while keeping rent stable for others in comparable units, can result in significant liability. Virginia also has specific provisions about how rent increases interact with the security deposit. Under Section 55.1(1226), the security deposit for a residential tenancy cannot exceed 2 months' rent. If a rent increase pushes the proportional deposit amount above this threshold, for example, if the landlord wants to collect additional deposit at the time of the increase, the landlord must ensure compliance with the statutory cap. However, most landlords don't adjust the security deposit at the time of a rent increase. From a practical standpoint, Virginia's rental market varies dramatically across the state. Northern Virginia, including Arlington, Alexandria, Fairfax, Loudoun, and Prince William counties, is one of the most expensive rental markets in the country, driven by proximity to Washington, D.C. and the federal government. Rents in Northern Virginia are substantially higher than in the rest of the state, and landlords in this area can typically implement annual increases that reflect the market's strong demand. The Hampton Roads area, including Virginia Beach, Norfolk, Newport News, and Hampton, has a more moderate rental market influenced significantly by the military presence. Naval Station Norfolk is the world's largest naval base, and the military population drives substantial rental demand. Rent increases in this area tend to be more moderate and are often influenced by military housing allowance rates, since many tenants are service members whose housing budgets are tied to their basic allowance for housing. Richmond, the state capital, has experienced significant growth in recent years, with rent increases reflecting the city's expanding economy and population. The Richmond market offers a middle ground between the high costs of Northern Virginia and the more affordable markets in the rest of the state. Southwest Virginia and the rural areas of the state have softer rental markets, where aggressive rent increases are harder to sustain because tenants have more options and the cost of living is lower. Landlords in these areas need to balance revenue goals against the risk of vacancies. One best practice for Virginia landlords: time your rent increases strategically relative to lease renewals and market conditions. In competitive markets like Northern Virginia, annual increases of 3 to 5% are common and generally well absorbed by the market. In softer markets, smaller increases, or even holding rent steady for a year to retain a good tenant, may be the more profitable choice when you factor in the costs of vacancy and turnover. Another best practice: coordinate rent increases with property improvements. Tenants are more receptive to rent increases when they can see tangible improvements to the property: new appliances, updated common areas, improved landscaping, or other enhancements. Timing an increase to coincide with visible improvements gives the tenant a concrete reason for the higher rent and reduces resistance. Virginia landlords who participate in the Housing Choice Voucher Program, Section 8, need to coordinate rent increases with the local housing authority. The housing authority must approve the new rent amount, and the proposed rent must be within the fair market rent for the area. The Housing Authority will compare the proposed rent to comparable unassisted units in the market before approving the increase. Landlords should submit rent increase requests to the Housing Authority well in advance of the desired effective date to allow time for the review process. One more consideration. Virginia requires landlords to provide a written rental agreement for any tenancy. Under Section 55.1(12)04, the rental agreement must include the terms and conditions of the tenancy, including the rent amount. When rent changes, the new amount should be documented, either through a formal lease amendment, a renewal lease at the new rate, or a written notice that becomes part of the rental agreement. Keeping clear written records of all rent changes protects both the landlord and the tenant. For the complete guide to Virginia rent increase laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.